On the record in the matter of the people of the state of Michigan versus Fadi Nazardine, 24-02884. Council Pierce.
May it please the court, Michael Nichols, P number 59391 on behalf and with Mr. Nasruddin. Mr. Nasruddin's by Zoom, Your Honor. I'm in person, not feeling well today, so I asked the court to have a little patience with him.
Yes. Mr. Nasruddin, can you hear us?
Yes, I can, Your Honor.
Okay, let's see. Today was the date that was scheduled for a preliminary examination. However, I do believe that this matter is now going to be an unconditional waiver to the circuit court. Is that correct?
Your Honor, it's actually going to be waiver with the Attorney General's office has offered a delay of sentence under 771.1. I know that there are a couple of circuit court judges who may not be willing to take a delay of sentence, so this will be a conditional waiver.
Okay.
If it falls through, we can come back.
Good morning, Your Honor. Robert Hayes, Assistant Attorney General here for the people, and people agree with Mr. Nichols' assessment.
Very good. Okay, so this is a waiver with condition, and that is contingent upon this plea being able to go through, which is a plea offer with a sentencing agreement under 771.12, which would delay the sentencing and then a dismissal at the conclusion of that time period, correct?
That's correct, Your Honor.
Okay. And so, Mr. Nasruddin, you understand that you do have the right to have a preliminary examination here in the district court, and you do have the right to require the Attorney General's office put forth evidence to establish sufficient probable cause that the crimes being brought against you were committed, and sufficient probable cause to charge you as the person who committed those crimes. You understand that?
Yes, I do, Your Honor.
Do you wish to give up your right to have that examination today?
Yes, I do.
Okay, and that's based on, oh, yeah, did I swear you in? I
You
probably
did not.
did it. Okay, do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do, Your Honor.
Thank you. Okay, very good. Okay, so again, you understand your right to have the preliminary examination and you want to give that right up today? You want to give up your right to
Yes.
exam today?
Yes, I
Anyone
do.
threatening to waive these rights today?
No, Your Honor.
Has there been any promises extended other than what's been placed on the record to get you
No,
to
Your
want to
Honor.
give up your exam? Okay. I find your waiver to be freely and voluntarily given. Your bind over date's gonna be the 19th of February. Now, you do not need to appear in the circuit court on the 19th unless your attorney files a motion to have you rearranged on that day in the circuit court, okay?
Okay.
Otherwise, you will not need to appear in circuit court until your next court date, which would be a pre-trial. Your attorney will be made aware of that date, okay?
Yes, Your Honor.
Do you have any questions for the court at this time?
No, I don't.
Let's see, bond was 10,000 personal recognizance. There was a, looks like he was permitted to travel because of work previously. I don't know if that's an issue that needs to be addressed still. Bond will continue as set. Any additional matters for the record?
Yes.
Go ahead.
Go ahead. If the court continue to allow Mr. Nasruddin to travel as necessary for work purposes, anything else we would get permission for from pretrial services.
Anything from you, Mr. Hayes?
Nothing from the people, Your Honor. Thank you.
Thank you. The court will amend the bond to allow travel for work purposes. You're all set.
Thanks, Your Honor.
Thank you, Your Honor.
Thanks, Bob.
Thank you. Thank you.
Bye, I'll call you.
Okay, thank you.
No problem. Ms. Archie, can you hear us? Angie,
Yes, Your Honor.
okay, do you know that your client is in custody in person, correct?
The last time with Judge Buchanan, we had asked her to consider this as a PCC because we are trying to have my client be screened for drug court, Your Honor.
That is my understanding, but for whatever reason, he's here. I don't understand. I don't know that she knew to have him put on Polycom, but he's here in person. So if you needed to speak to him, we would not be able to accommodate that.
I don't need to speak with him, Your Honor. We communicate by spot communication all the time. So he knows that what our plan is to have him screened for the drug court before we move forward.
Okay, so we'll have him brought up in a moment. We have some other people being brought up right now.
Thank you, Your Honor.
No problem. Do that one now. Yes. Okay. On the record in the matter of the people of the state of Michigan versus Aana Stevenson, 25-00202.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Toby White. On behalf of-
She's sight impaired, so she has a person helping her get through the doorway.
Oh, sounds good. Today's the date scheduled for a preliminary examination. There's a request for an adjournment.
This is a request for adjournment with new on the case, and I talked to the prosecutor. There's no objection. So future date, we'll be ready then and see where it leads.
That's accurate, Your Honor. We have no objection to the adjournment. I believe Mr. White's office was just retained last week. I think it sounds like discovery has been turned over, but he's still reviewing it. So I have no objection to the adjournment.
Ms. James is out of the office this week. She had her mother passed away, so she's
Oh, I'm sorry to hear that.
maybe it's a little shorter.
Okay, and then Ms. Stevenson, you understand your right to have a preliminary examination within 21 days of the date that you were arraigned? Yes. And because you recently retained counsel, additional time is needed for them to prepare for your exam. Are you willing to waive the 21-day timeline so that this can be reset? Yes. March 27th at 8:30. March 27th at 8:30 work?
That's what it is.
Thank you. Okay, we'll set it for March 27th at 8:30 in person at the court to get you notices to appear. Any additional matters for the record today?
Not for the people, Your Honor.
Nothing for me, Your Honor. Thank you.
Okay, you're all set now.
Thank you.
Thank you. Okay, on the record in the matter of the people of the state of Michigan versus Desa Reed, 24-03395. Council appearance.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, man. Please, this honorable court, Kareem Johnson, P number 71988, appearing on behalf of Ms. Reed.
Let's see if I can, you can get your children if you want to. I'm gonna see if I can find it. Okay, so Ms. Reed was scheduled today for preliminary examination. I do see that there was an offer extended for the defendant to plead guilty to amended count 1 of attempted restricting opposing an officer and count 3 malicious destruction of a building.
I apologize for the handwriting.
No, that's fine. It says you're gonna dismiss count 2.
Correct, yes, Your Honor.
Okay, consent to HYTA, and there's an agreement for restitution. Is that complete and accurate?
That's correct, Your Honor.
Yes, Your Honor.
You know how much restitution is at this time?
Not at this time, Your Honor. We will have that settled by 2017.
Your advice and rights.
Yes, Your Honor, may I approach?
Let's see, raise your right hand, Ms. Reed. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Yes. Okay. Do you understand that you were scheduled to have a preliminary examination today and that there's been an offer for you to plead to misdemeanors? You understand that? And you want to accept that offer? This is an advice and rights and plea information sheet. Put today's date on. Do you understand all the rights that's listed here? Yes. Do you have any questions about these rights? Yes. Okay, and that's your signature here? Yes. Okay, so you're willing to give up these rights in order to plead guilty to the amended count of attempted resisting, obstructing officer, and also in order to plead guilty to count 3, which is malicious destruction of a building, correct? Yes. Okay. You can bring it. You can bring it. You understand that you have the right to be presumed innocent until proven guilty. So that means that you have the right to require the prosecution prove each element of the charges that you're being charged with, and they have to prove each element beyond a reasonable doubt. Do you understand that? You have the right to remain silent at any trial and not have silence be used against you. You have the right to see, hear, or question in court any of the witnesses that they call to testify against you. You can subpoena witnesses to testify on your behalf and present evidence that you believe show a defense to these charges. And you also have the right to waive your silence and testify at your own trial. These are all rights that you would give up today. You understand that? Yes. Is anyone threatening you to give these rights up? Yeah. Any promises being made to you if you give up these rights? Are you currently on probation or parole? You understand that by pleading guilty, it could result in a conviction that you may need to report to your current employer, or you may need to report this conviction on a future job application. It also could have impact on where you can travel or get immigration status. So you may want to go out the country one day, and this conviction could have an effect on that. You understand that? Yes. Okay. As to the amended count 1 of attempted resisting obstructing officer, how do you plead? And as to count 3 of malicious destruction of the building, how do you plead? A factual basis, please.
Ms. Reed, on November 14th, 2024, were you in the city of Lansing, County of Ingham?
Yes.
Did you go to an apartment complex? Did you break a window at that apartment complex? You did so intentionally and maliciously. You were upset. Later on that day, were you in the area of that apartment complex? Did you have contact with a police officer?
Yes.
Police officer wanted you to stop so he could try and talk to you about the broken window?
Yes.
And did you resist that police officer's directions? Got a defense is satisfied. And we stipulate the value.
No questions, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. This matter is set for sentencing April 3rd at 9 o'clock in the morning. When you leave here today, you're gonna go down 1 floor to our probation department and check in so they can get you set up for a pre-sentence interview. They'll advise the court as to whether or not you are eligible for a status under HYTA, okay? And you can appear for your next court date, which is your sentencing date. You can appear for that via Zoom as long as you have video, okay? Do you have any questions for the court? And so, any additional matters for the record at this time?
No, Your Honor.
No, Your Honor. Thank you.
Okay. And then Mr. Nagel will get us the restitution actual amount. Sounds good. Thank you.
So, I'll go ahead and next one.
Okay. Mr. Braxton, and that's Donald. On the record, in the matter of the people of the state of Michigan versus Carlton Donald, 5-00141, council appearance.
Good morning, Your Honor. Matt Nagel for the people.
I'm sorry, you got Fred Blackman on behalf of Mr. Donald.
Okay, Mr. Donald is present here. And today was the date and time scheduled. This is for a preliminary examination, Mr. Donald, on a weapons, firearms possession by a prohibited person. I have a count 2 weapons, ammunition, possession by a prohibited person. Count 3 weapons, body armor, possession or used by violent felon. And then count 4 weapons, felony firearm, as well as 5 and 6, which are felony firearms. And then habitual offender, second offense notice, which enhances the maximum penalty on the primary offense. And so my understanding, Mr. Donald, is that you want to waive your preliminary examination. Raise your right hand if you can. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Put your hand down. Okay, Mr. Donald, you understand that the purpose of the preliminary examination is to require the prosecution put forth evidence that would establish if they have sufficient probable cause that the felonies that you're being charged with were committed, and then sufficient probable cause to charge you as the person who committed the felonies. You understand that? And you wish to unconditionally give up your right to have that exam? Okay, anyone threatening you to do that? Has there been any promises made if you give up your examination?
No.
You understand that this is being waived without condition, so you can't get to the circuit court and decide, you know what, they didn't give me a plea offer, so I want my exam. You understand that? Okay, was there an offer on this?
Not at this time, Your Honor.
And the people are waiving their exam.
The people will be making an unconditional waiver of our exam.
I find your waiver to be freely and voluntarily given. Mr. Donald, your matter will be bound over to the circuit court. Your bind over date is going to be the 19th of February, okay?
The record got my client and myself have signed it along with the prosecutor.
Thank you. So the bind over date again is going to be the 19th of February, but you do not need to appear in circuit court on the 19th unless Mr. Blackman makes a motion for you to be rearranged in the circuit court, okay? Otherwise, your next court date is going to be a pre-trial in circuit court. That date will be provided to you and your attorney after the 19th, okay? Do you have any questions for the court? I'm gonna set it 2,000 cash surety that will continue. Any additional matters for the record, counsel?
No, Your Honor, thank you.
Any additional matters, Mr. Blackman?
Nothing, thank you.
Thank you, your honor. On the record, in the matter or matters of the people of the state of Michigan versus Darren Clark, 24-03775, 25-00155, and then 24-03774.
Morning, Your Honor, Matt Nagel for the people.
Morning, Your Honor. Robert Palmer, the Public Defender's Office. On behalf of Mr. Clark, the gentleman to my right, I represent Mr. Clark on all three files. He's got, I'm sorry.
Yes.
He does have he's got a misdemeanor case that he was on probation for. It was set for sentencing, I think, a week or so ago. He was, but the court was in trial that day, and so he's now got a new misdemeanor. He's now got a new sentencing date. I think it's the 20. I can look it up. It's like the 22nd, 24th, something. 24th.
Okay.
Ms. Sutter represents him, and she's here present.
Great. Okay, so these matters are felony matters that, my understanding, there's going to be a waiver on.
That's correct, Your Honor. This will be an unconditional waiver on all three files. As I said, it's an unconditional waiver. We anticipate the plea offer will be at the circuit court that he pleads to the methamphetamine case with the dismissal of the two retail fraud cases, and will seek treatment, substance abuse treatment in some form. What that looks like exactly at this moment is, I guess, open for negotiation is a fair way to say it, but nonetheless, it is an unconditional waiver.
That's accurate, Your Honor. With just to add, though, that I think there's also going to be an agreement to restitution on one of the two retail fraud cases. I believe there's only restitution on one of the two. But other than that, that is an accurate statement of the offer.
I'll confirm that. He did say restitution, Your Honor. I did drop. Approach.
Yes. Thank you.
Just want you to make sure you ask me a question. Question. Yeah, you're right.
Here's the rest of them. You know what I'm saying?
Okay. And then we'll just place it on the trial.
Yeah. rather than-
Okay, I mean, I get it. He wants you to get on the issues.
Thank you, Judge. We've executed forms. May I approach?
Yes.
I'm getting to-
Oh,
Okay. Raise your right hand, sir. You solemnly swear or affirm the testimony you're going to give the truth and the whole truth under penalty of perjury. Okay, you can put your hand down. Mr. Clark, you understand in each of these matters, you're being charged with felonies. You understand that you have the right in each of these files to have a preliminary examination on those felonies in which you can require the prosecution to establish that they have sufficient probable cause that these felonies were committed and probable cause to charge you as the person who committed the felonies.
yes, ma'am.
Do you wish to unconditionally waive your exams today?
Yes, ma'am.
Anybody threatening you to get you to do that?
No,
Any promises being made to you if you waive these exams? And you understand that the waivers are unconditional, meaning you can't get to the circuit court and decide, maybe you don't like your plea offer. Once you waive it, it's over. You understand that? Find your waivers to be freely and voluntarily given. Your bind over dates February 19th. That's the date that the circuit court gets these files from this court, not a date that you need to appear in the circuit court unless your attorney wants you to be rearranged. If he does, he will need to make a motion for that, okay?
yes, ma'am.
Your next court date will be a pre-trial in the circuit court. Do you have any questions at this time? Bond and file number ending in 774 is 3,010%. That will continue. Bond in 24-03775 is 3,010%. And that will continue. Okay, bond in file number 155 is 10,000 personal recognizance with GPS tether. I don't see any order for testing. I'm gonna add.
Judge,
If we postpone, he's gonna be tested.
yeah, I know no issues with that, but if it's 10,000 personal recognizance, could I ask the court to
He's not
convert
giving
that
you
to?
time.
Right, exactly. Can I ask the court to convert that to a 3,010%, being consistent with the other files? he's already being held with no bond on the probation violation that's set for a couple of weeks from now. I'm not addressing bond today. I'd like him to at least be earning credit on all of the files so that we don't have to deal with this issue.
That's no problem. I'll amend the bond so that he can be accruing some time on this. It'll be 3,010%. Again, I've added the testing requirement on that file.
Thank you, Judge.
No problem. Any additional matters for the record?
Not for people.
Not for the defense.
You're all set. Yeah. We need Nicholas, and he's gonna be. What do we do with Nicholas?
Is that one, the treatment, the PCC, the treatment?
Yeah, it's gonna be, I guess, another PCC, so that'll be short, and then if we can get security assistance, we need them also to drink. We're about to run here.
So that's Sims, Your Honor, and then
Ryan Sims.
sounds like Young is going to be a plea. Young, what's his name?
Yes, Young's in custody.
You can bring up Nicholas and Sims.
Nicholas and.
Thank you.
Yeah, are you doing, the Dunach competency hearing on that at all?
He's not even highlighted. Is he gonna be on?
Wasn't sure, I got, Ms. Robinson, I got an email from your court staff saying it was a hearing today. I haven't.
No, it is on the docket. I'm just trying to figure out.
It's just a 90-day review.
Yeah, I'm just wondering if he's gonna be, is he in custody? Like, where is he? He's not highlighted on my docket, so that highlighted on in pink means he's in custody. He's not, so that makes me feel like he's here.
No, but then I kind of assumed he'd be on the
Yeah,
call from, so I didn't ask if he was downstairs.
On the jailers. He got to me? No. Interesting. Is he at the facility? Must be in the facility. Yeah, that'd be it. I don't believe that. I don't believe that.
And I'm sorry, I was talking to Mr. Clark. I think I heard you say he is downstairs.
I'm sorry?
I'm sorry, I was talking to Mr. Clark. I didn't think I wasn't, I heard you say, you said he is downstairs. He's not.
He's not. He's not in custody.
No, he's not on the jail list at all for New County, but
I think
he might be in the
he
facility.
might be at the, I thought he was in the forensic center.
He was there, I think my remembering of the report is they are treating him. He's not yet competent at the 90-day. They think they can still restore him to status, so I think they're just asking permission to continue. I just haven't.
Yeah,
seen
I'll
Ms.
just
Robinson
call.
this morning.
You haven't seen who?
I haven't seen Ms. Robinson here this morning for that because it's her case, so I hung around for it in case she's not here.
Oh, okay, yeah, if maybe Mr. Nagle comes, I'll just follow it on the record.
Okay, thank you.
Let's see what's going on. Okay, on the record, in the matters of the people of the state of Michigan versus Dennis Dunach, 24-01506, 24-02154, and 24-02690. Appearances, please.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, also appearing in place of Attorney Aaron Robinson on the FY file on behalf of Mr. Dunach, whose appearance I'm waiving for today's hearing.
Thank you. Today was the date that we scheduled a review. I do have a report from the Department of Health and Human Services Center for Forensic Psychiatry. It was from January 21st. Counsel, I think the defense did get a copy. Did the prosecution get a copy?
We did, Your Honor.
Okay, the opinion is that at this time, he still remains incompetent to stand trial, and they're seeking to continue treatment to see if he could be restored within the statutory time frame. Any reason to make any objections to the body of the report or the request for continued treatment?
Not for the people now.
Not on defense for the behalf of the felony. I don't know if we've reached the maximum timeline for the misdemeanor cases, so I don't know if we'd have to do anything there, but certainly for the felony, there's no objection to the continuing.
I don't believe we reached the statute on it. Didn't even see them. Okay, so it looks like he was sent on competency at the end of September.
Right, and my only thought about the misdemeanors was if maximum timeline is 2/3 the maximum sentence, and today's the 90-day review on 293 misdemeanors, that was my thought with the maximum timeline allowed on those.
Is there a competency on each of these? Yeah.
Why they're all on today, but
Oh, that's for criminal responsibility. I see them for the, one file, I don't see it even a row for competency on. Okay, let's see. I do, this is in the other file. October 28th. That's the date, it looks like.
yes, Your Honor, I think I've got a signed order in my file from November 5th. I recognize at least one of these cases today is with the city, but I have two with the state today.
I'll leave that to you, you all and the prosecutor or city to work out the statute and if they need knowledge or whatever reason. We can do so. The felony though is going to
Absolutely.
obviously continue.
Ask about this
So do you
back to
only
my
need
office,
the
'cause it doesn't
order for
differentiate
the
between
felony?
I need it for all. Oh,
one third. So, I mean, so basically, it looks like it supports what you're saying. So I want to follow up and if so. Right, yeah, but I just want to. Look at the rules. Right, so that's why I'm interpreting what you are, so I just want to check, make sure you have it right.
thank you. On that one. Anybody up there?
And I'll include Mr. Waddell.
Yeah, who?
I'll include Mr. Waddell as well.
Oh, okay, sounds good. Let's see. This is the felony.
Yes, good luck. Thank you, Nancy.
How's it going?
Good morning, Judge.
Look at you, you got all this new swag. What's that all about?
Oh, this is back in the day when I used to work for AG.
The AG, no, I too used to work with AG. They didn't give me I mentioned that to someone recently. I said, where are y'all getting all these like swag dolls?
I'm gonna agree with you because there's even Ingham County prosecutor swag and I don't even know where they're getting it. I'm feeling left out too.
You get like once a year, they give you like a thing you can order.
Okay, on the record, in the matter of the people of the state of Michigan versus James Nicholas. This is file number 25-00195. Council appearance.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. And you'll be watching for Mr. Nicholas, who is in court in person.
Very good. Okay, today was the date that was scheduled for a preliminary examination. This is for controlled substance possession. I think there was a trespass that was to a company, and then my understanding is that this is a matter that is being screened for specialty court.
That's correct, Your Honor. We were originally scheduled for an exam today, but we had this reset as a probable cause while Mr. Nicholas is being screened for, I think it's drug court. Believe the screening is ongoing. And there was another matter we were before the court on yesterday. I think we had that set out long enough for the screening to continue. I think we would ask that this be moved out and joined with that other case to keep them together while he continues to be screened for drug court.
So, counsel?
Yes, Your Honor. The only thing that my client would like to waive his 21 days to have his preliminary exam done within the time frame required by law.
Thank you. Okay, Mr. Nicholas, you understand that you have the right to have a preliminary examination within 21 days of the date that you're arraigned? You understand that? And because your matter or your matters are being screened for you to possibly enter the specialty court, do you want to waive that timeline so we can set this out? Okay, anyone threatening you to do that? Anybody promise you anything if you waive the timeline?
So the other wasn't set out, it's the treaty at the PCC next week. So do they want that one approved too?
Okay, so the other one, we did not set it out. I think we said we was treating like a PCC next week.
Yes, Your Honor.
Oh, okay.
Okay, so we'll set this one out, I suppose.
March 27th at 9:30.
March 27th at 9:30. And as to the other one, did you still need to treat that as a PCC, or do you want us to address that one?
You know, I think we can address that one for judicial efficiency.
I mean, I have to find another.
I apologize. It's probably a case of selective memory.
Okay, State of Michigan versus James Nicholas, 25-00211. Council appearance on that one.
Matt Nagel for the people.
Daniel Biwanji for Mr. Nicholas.
Okay, now Mr. Nicholas was before the court yesterday via Polycom, and we addressed this matter, but consistent with the matter that we just addressed, this one as well is going to be considered for the specialty court, correct?
That's correct, John.
Yes, Your Honor.
Okay. Okay, and so Mr. Nicholas, even on that matter from yesterday, you have the right to have your preliminary examination within 21 days of the date that you were arraigned. But because of the screening process for specialty court, did you want to waive the timeline on that one as well so we can reset it? Okay. So we will reset that matter as well till March 27th at 9:30. Any additional matters? Is he being held on anything?
He's not, Your Honor. He only has a bond on that case. I think it's something like $300. And I will check and see whether or not there is a bed available and at the so that we can get a PR bond to allow him to go to treatment.
Okay, the reason I asked is because there is a PR bond on this one, so he's not accruing any time on this file.
That's
so if you want me to amend it, I can amend it so that he can accrue his time, and then if he gets a bed, we can amend both to PRs.
Thank you, Your Honor. That would be wise for us to do that. Thank you.
Can I say something?
Yes.
House of Commons is rehab I finished before. Is it possible could we see if there's bed there?
Okay. Ms. Wanji, did you hear his request?
I couldn't hear.
House of Commons he would prefer to try to go back to House of Commons because he's been there before, but we understand that there may not be availability, but I wanted to make sure you heard his request.
Thank you, Your Honor. I have now.
Okay, so yeah, I don't, the court doesn't have any control over where you're going to go, and your attorney is working to try to get a bed, figure out where there's going to be a bed available, okay? Okay, I'm going to amend your bond on this so that while you're sitting, you're accruing time. So it's not dead time. And so it's going to be amended to 2,010%. And then your attorney will make us aware once a bed becomes available so that both of your files can get a PR bond so that you can go to the facility. Okay. Do you have any questions? Any additional matters for the record?
No, Your Honor, thank you.
Thank you. You're all
Thank
set.
you, Your Honor.
Good day, y'all.
Same to you.
Thank you, Your Honor.
Thank you. On the record, in the matter of the people of the state of Michigan versus Craig Sims, 25-00174. Council appearance.
Good morning, Your Honor. Matt Nagel for the people.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Sims, who's standing to my right.
Okay, Mr. Sims scheduled for a preliminary examination today. As police officer assault, resisting, obstructing, and there was a misdemeanor domestic violence.
That is correct.
Okay. Are we ready to proceed?
We are, Your Honor.
Yes, Your Honor.
Okay, any preliminary matters?
Not for the people.
I guess we would just ask for any witnesses to be sequestered in this area.
Sequestration is granted. It's police witnesses, obviously, correct?
Just one. police
Just one witness, so no reason to sequester. You can have a seat and you can call your witness.
Thank you, Your Honor. People call Officer Mark Fox.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Thank you. You can have a seat. You can state your first and last name and spell both.
Mark, M-A-R-C, Fox, F-O-X.
Counsel, you can proceed.
Thank you, Your Honor. Officer Fox, can you tell the court with whom you are currently employed?
Lansing Police Department,
How long have you been employed with Lansing Police Department?
about 2 years.
And what are your current responsibilities with Lansing Police Department?
I'm a patrol officer.
And what are some of the things you do as a patrol officer with LPD?
I answer calls for service. I mean, traffic stops, basically anything the city needs while I'm out in the field.
Thank you, sir. And on January 22nd of this year, were you employed in that capacity?
I was.
Do you recall being dispatched to a location regarding a domestic violence complaint?
Yes, it was off Glen Rose, I believe.
Was that 1404 Glen Rose Avenue?
Correct.
And is that in the city of Lansing?
That is.
County of Hingham?
Off
Yes.
the record. Who's saying your name? Somebody said that. Interesting. Name sounds familiar. This one you have to warn you. That's it. I'm about to boot you. You're gonna disrupt my court and then I think I need to watch you do whatever you're doing. Bye. You can continue. Can you repeat the address for me, please?
Yes, Your Honor. Officer Fox, that address, was that 1404 Glen Rose Avenue?
Yes, sir.
And is that in the city of Lansing, County of Hingham?
Yes, sir.
Did you go to that address?
I did twice that.
And were you the first one on the scene?
Negative. I was technically third on the scene. There was a Boston unit that was there prior to my arrival.
Thank you, officer. Can you tell the court what happened when you got there?
So as I was approaching the scene, Officer Ramsden called out he had one at gunpoint. And when I arrived on scene, Officer Ramsden's recruit officer was bringing a gentleman out to the road. And I offered to put that gentleman in the back of my vehicle. As we got to my vehicle, Officer, I can't recall her name, she's a recruit officer. She stated to me that the handcuffs were not double locked. I said I would double lock the handcuffs. I double locked the handcuffs and had a conversation with the defendant about getting in the back of the vehicle, so that he didn't do anything and didn't want to get in the back of the vehicle. And I said, sir, we'll sort this out in court. I then, once he was secured, his handcuffs were secured properly.
Yeah, I believe he's gone beyond the original question at this matter, is testifying in the narrative at this point.
I agree.
Sure, that's fine. Officer, before we move on, can you tell me when you arrived, what kind of vehicle did you arrive in?
I arrived in a patrol vehicle. It was an Explorer.
And was that marked?
Yes, it was a fully marked patrol vehicle. I was in full uniform.
And you were, okay, I was gonna ask you next, you were in a full uniform, and I think you mentioned that you were probably the third one on the scene that, okay. So the other two who were there, were they also dressed in their LPD uniforms from what you could observe?
Yes.
Okay. Do you recall whether or not you identified yourself as a police officer when you got there? Maybe you didn't have to.
I don't think I identified myself verbally as a police officer.
But you were wearing a uniform?
I was wearing my full uniform.
Okay, thank you, Officer Fox. Okay, so I think you said you were told somebody had one at gunpoint. What does that mean?
So it means that the officer that was on scene was pointing a firearm at the accused subject on scene.
Okay. And did you arrive to assist with taking this person into custody?
Yes, I did.
And was this person already detained by the time you got there?
Correct.
And you said something about the handcuffs were not double locked. Can you explain to the court what that means?
So once the handcuffs are closed, there's a small plunger in the side of the handcuff that you use the back of your key to click, so the cuff doesn't get any tighter when they're in the back seat. So procedure is fit check and double lock the cuffs.
So is that a requirement that the cuffs be double locked on everybody taken into custody?
Yes.
Okay. And I think you mentioned that this person was under arrest.
Yes, at this point, I believe this person was under arrest.
Do you recall what this person was under arrest for?
At this point, domestic violence.
Okay. And then you took control of this person?
Yes.
Was that person identified to you?
As it was Craig Simmons identified to me. I knew who he was based on our initial, because we went to this residence earlier and then we got a return trip back to this residence for another disturbance.
Okay, so you knew who this person was?
I knew who he was. Correct.
And so because you know who this person was, would you recognize him if you saw him again?
I would.
Did you see him in court today?
I do.
Can you point to him and identify something he's wearing, please?
He's wearing a blue jumpsuit.
Your Honor, can the record reflect that? Please?
No objection. That's
So noted.
So once this person was turned over to you and you were informed that the handcuffs were not double locked, what was your responsibility at that point?
My responsibility was to double lock the handcuffs in accordance with procedure.
Okay.
So
and did you do so?
I did so.
And what did you do next with the defendant?
So next procedure is to search the accused, search incident to arrest for putting him in the back of my patrol car. I stated to the subject that he was getting in the back of my patrol car and he was under arrest. And I asked him politely to spread his feet nice and wide. So that's the procedure, to spread their feet so I can get a good search to make sure they don't have any weapons on before they get in the back of my vehicle.
And did he comply with that command?
He did not. I asked him the first time, he turned away from me facing the other officer. I did turn him back around. The second time I asked him, again, spread your feet nice and wide, please. He did not. The third time I assisted him and slid his foot out.
Okay, you slid his foot out. How'd you do that?
I used the inside of my right foot on the inside of his left leg area, and I slid his foot out.
Okay.
So his feet were spread wide.
And can you remind the court what the purpose was for doing that?
So the purpose is, number one, officer safety, and it's in a tactically sound position, so I can search this individual in case they're hiding weapons anywhere. People hide weapons in all sorts of places.
Okay. And was he saying anything to you during this time?
Initially, he said that he wasn't getting the car because he didn't do anything, and then he was quite upset with me that I slid his foot out.
Were you able to complete the pat down then?
No, I got started on the pat down, and the accused body checked me.
What does that mean? What did you do?
So his hands were behind his back, and I'm standing off to his left side, and he hit me with his body, and I had to take control of his arm and push him up against my patrol vehicle.
Okay. Once you had him up against your patrol vehicle, was he compliant at that time?
He was not. I asked him if he was going to be compliant, and he was yelling at us that I kicked him.
Okay. What happened next?
I told him that to get into the back of the vehicle. I felt fairly comfortable. He didn't have any weapons he could hurt me with at that point in time. I was going to get him in the back of the vehicle. I turned him towards the entryway, so the door was already open. We searched all accused with the door open in the door jam. The door was already open. I pushed him towards that. He locked his legs out and tensed up his entire body, pressed his head against the top of the door frame of the vehicle, and locked his legs out. I again gave him continuous commands to get inside the vehicle. At one point, I reached up and I grabbed the top of his head and I pushed him down and into the doorway of the vehicle.
So let me ask you this: was he under arrest at that time?
He was under arrest.
And you mentioned that was for domestic violence. Had you informed him that he was under arrest at that time?
I had informed him he was under arrest.
Okay, so so the purpose for putting him in the back of the vehicle was because you were going to take him to the license police station?
I was going to take him to jail.
So how were you able to get him in the back of the vehicle?
So initially I got his head down and I got his, he was facing away from me and I got him head first into the vehicle and Mr. Sims spun on me and I'm standing, I think this is very important. I'm standing on ice and snow at that doorway and he spun on me and was screaming in my face and trying to force his way back out of the vehicle. So he was partially in, I believe his butt was maybe on the seat, but his legs were outside of the vehicle. And he got very close to my face, screaming at me. And I pushed him on his chest and then pushed his head away from me, get control of the head to keep him inside the vehicle. The last thing I wanted to do is both of us to fall out of the vehicle.
What happened at that point?
He rolled his head over and bit the side of my left hand.
And you are indicating the
meaty portion just below my pinky on my left hand.
Thank you, Officer. What did you do in response to him biting you?
I was going to strike him, but he let go at the last second and I did not hit him. And Officer Donovan Moore went around to the opposite side of the vehicle and grabbed him and pulled him into the vehicle.
Okay. And was it at this point you managed to finally have him secured inside the back of the vehicle?
Yes, we got him secured inside the back of the vehicle.
From there, what happened next?
Closed the door. I checked with the officer on scene that I was good to go to take him downtown. I was advised that I was, and I transported him down.
Thank you, Officer. No further questions at this time.
Prosecutor.
Morning, officer.
Morning, sir.
So, officer, you stated that you were about the third person on scene. Is that accurate?
Yes.
And when you arrived, Mr. Sims was already in custody. Well, not okay. He was already handcuffed. I was just talking at the same time there. Okay. So he was in handcuffs, and was it an Officer DeSmith, or what you said, a recruit?
Yeah, recruit Officer DeSmith. She's Officer Ramson's recruit officer.
Okay, so is she officially an officer at this time? But so she is walking him from the location he got handcuffed all the way down to the road where the car is. Is that accurate?
Correct. When I met them, they were halfway down the driveway.
Did Officer DeSmith appear to be having any problems with Mr. Smith?
No.
Or Sims at that time?
No.
And she essentially hands him over to you right near the car?
She was there for the entirety of the incident, yes.
And I guess you said Mr. Sims was arguing about whether or not he was guilty. Is that what was happening at that time?
Yes, he was stating that he didn't do anything and nothing happened. I can't remember exactly what he said. I wrote it in my report, but he was arguing about the fact that he didn't want to get back to the vehicle. I advised, he said he wanted a jacket. I advised him, well, you're gonna be going to the back of my car here in a second. And he was upset that he was gonna go back to the back of my vehicle.
In your experience as an officer, is it fairly common for people to argue about whether or not they had done anything wrong when they were being arrested?
Sometimes.
Not the first time that you saw
Not
they
the first
dealt
time.
with that. And it was, when you say you were trying to get Mr. Sims to widen his feet, you essentially kind of kicked out his I think left leg to
Yeah,
widen
I
his
slid out
feet.
his left leg, correct.
Okay, and that's what seemed to set off Mr. Sims, in your opinion?
Yeah, I think that was maybe a catalyst to him, but he was already pretty up there. Just talking with him, I could tell he was just not gonna be compliant with us.
Okay, so, but then, like you said, but you, after you kicked out his feet, is when his behavior maybe went to another level, in your opinion?
Yes.
And it's about you're trying to essentially stuff him into the vehicle from there,
Stuff him into the vehicle.
push him into the vehicle.
Yeah, I'm trying to get him detained inside the back of his car.
Now, did you notice that the seat belt for your back seat was essentially locked at that time?
So these vehicles are opposite of a normal car, all right? And so the seatbelt clicks in the front edge. That way I don't have to lean over the accused to seatbelt him. All right, I could just grab it from here and close it. Had Mr. Sims stepped inside of the vehicle, I would have reached up and grabbed this and slid it over and locked it on the outside edge.
But wasn't it already locked at that point?
No, it was not locked. It is, so you have the seatbelt in the middle, you have a seatbelt buckler where it connects up front, and then you have the seatbelt buckler on the side. Normally, when you sit in the back seat, you take your seatbelt from this end and click it in the center. Ours are opposite. So my seatbelt is clicked into the front edge of the door frame. So where the door meets, it's clicked into the front edge right there. It has another seatbelt buckler. If the accused were to get into the vehicle, I would then grab it from here and then close it over him. It's designed so it's an open area for him to sit in the back of the
However,
vehicle.
if it had been locked prior to him being in the vehicle, that would block his entry into the vehicle, correct? The way that a police officer's car works, opposite. of regular-
If the seatbelt was already over the seat,
Yes.
there would have been absolutely nothing blocking him from getting in the vehicle then, because the seatbelt would have been tight to the seat. So the
Okay.
seatbelt is designed to be open, so they can sit in the seat, and then I can close it, so if we do get into a car accident, that he's safe in the back seat. But if the seatbelt had been closed and locked, it would have just been laying flat against the seat. There would have been nothing obstructing it.
But didn't Officer Moore have to go around the car and assist with the seatbelt before help him get
So,
Mr. Sims into the
at that
vehicle?
point,
Wait a minute, let him finish the question before you speak.
Okay, so didn't Officer Moore have to go around to the other side of the car to assist with seatbelt issues before getting him into the vehicle?
So, Officer Moore had to pull him across the seat. Now, in order to pull him across the seat, yes, that seatbelt would have been blocking him. So Officer Moore had to disconnect that safety connection we use, had to disconnect that to pull him into the vehicle.
Okay, and there seemed to be no resisting by Mr. Sims of anything that Officer Moore was doing. Is that fair to say?
I'm confused. I don't understand.
Okay, Mr. Sims did not appear to have any issues with Officer Moore's handling of him in the car?
I don't think he really had a choice. I mean, he's facing me in the doorway, and Officer Moore grabbed him by his clothing and pulled him into the vehicle. So.
Okay, but he didn't swing at Officer Moore or body check Officer Moore or anything along those lines?
I don't think he could have.
But he didn't. I didn't ask if he could, but
I did. No, he was handcuffed. He couldn't swing it.
And you also stated that Officer DeSmith, when she walked Officer Mr. Sims out, she didn't have any issues with Mr. Sims?
Not that I saw.
I'm gonna actually object to that question as beyond this would just, we have no personal knowledge of what happened prior to age of Waiver, honestly.
I can ask.
Yeah, I think he answered it appropriately, said not that he saw, so.
And you did arrive on scene while she was walking him down the driveway?
Yeah, they were in most of the way down the driveway when I walked up. Yeah.
And at some point you started, didn't you resort to using pressure points around Mr. Sims' throat to get him into the vehicle?
No, my thumbs were in that area. That was after I was bitten by Mr. Sims. I grabbed him over the muscles on his shoulders because we're standing in the doorway. I'm sitting on ice and trying to hold him into the vehicle. One of the pressure points is the clavicle notch in and down. I thought about utilizing that, but at that point in time, we were kind of stuck where we were. And I could hold him without utilizing a pressure point.
Okay, so you'd say, you testify that your hands are essentially on the shoulders and the thumbs toward the middle.
Yeah.
At some point, you also essentially hit Mr. Sims in the mouth during this struggle going on?
No, I didn't actually punch him. He released his bite before I hit him.
Okay, were you, since you threatening to hit him, is when you claim he bit you?
Was I threatening to hit him?
Yes.
I don't recall what words came out of my mouth.
I guess were there some, unkind words being exchanged by both parties at this time?
I believe I was very polite in the beginning, and I was a little more stern when I repeatedly told him to get inside the vehicle. And I mean, after being bitten, I was probably a little more stern after that. I cannot recall exactly what I said at this time.
When you finally got Mr. Sims into the vehicle, did you feel the need to, did you ask fellow officers, did I act appropriately there, or did I get too hostile or something along those lines?
I don't recall what I said on scene after that.
No further questions, Your Honor.
Just a couple follow-ups. With respect to when Officer, was it Officer Donovan Moore?
Yes, sir.
When Officer Donovan Moore pulled the defendant in, was the defendant in handcuffs at that time?
Correct.
And when Officer Moore pulled him into the vehicle, was it from the front or from behind?
From behind.
And from what you could see, did it look like the defendant was aware Officer Moore was behind him at the time he was pulled in?
I don't believe so. He was pretty focused on me.
Okay. With respect to when your hand was in his face, I think you testified on direct that just prior to the defendant biting you in the hand, he was leaning back out of the vehicle, his head close to your face. Is that correct?
Yes, he was trying to push his way out of the vehicle.
And so when your hand was in his face, was that a strike or were you pushing his face out of your way?
I was pushing his face out of my way, pushing head control. I was controlling his head.
And on direct, you testified that you had thought about hitting him, but you did not while he was biting you. When he was biting you, was that a soft bite or did you experience any pain?
I experienced pain. My hand was sore for a few days after that.
And so your hand was what?
Sore for a few days after that.
Thank you, officer. No further questions.
Let's see. You may be excused, Officer Thomas.
Thank you.
Any other witnesses?
People rest, Your Honor.
That's witnesses. Is that witnesses?
No, Your Honor.
We can proceed to argument.
Thank you, Your Honor. The people would ask that this case be bound over as charged. That would be resisting, obstructing in count 1, the domestic violence misdemeanor in count 2, as well as the habitual second notice. With respect to the elements of this count 1, the people have the burden of showing probable cause that first the defendant assaulted, battered, wounded, resisted, obstructed, or opposed or endangered. In this case, Officer Mark Fox, who was a police officer with the Lansing Police Department. In this case, the testimony established that while Officer Fox was trying to do an inventory search of the defendant after both the officer and the defendant were notified that the defendant was under arrest at that time, the defendant resisted the officer's efforts to search, refused to comply with orders to spread his legs, and kept turning back toward the officer. And at one point during the search, the defendant actually struck the officer using his body as the witness identified it as a quote unquote body check to the officer. The officer continued to search, and while he was being placed in the vehicle, the testimony also shows that the defendant bit the officer in the hands while the officer was trying to move the defendant's face away from his, while the defendant was close enough to the officer to make the officer feel in fear for his safety. Second, that the defendant knew or had reason to know that that Officer Mark Fox was a police officer. The testimony here establishes that Officer Fox was the third officer to report on scene. Testimony showed that the first two officers to arrive were also in uniform. Officer Fox arrived on scene and was placing the defendant in the back of a marked Lansing Police Department vehicle. Officer Fox also testified that he was dressed in his Lansing Police Department uniform at the time of this arrest. And third, that the officer gave the defendant a lawful command while making a lawful arrest or was otherwise performing a lawful act. And in this case, Officer Fox was putting the defendant in the back of the vehicle following a arrest for a domestic violence allegation. The defendant was notified at the time that he was being put in that he was being searched and placed in the back of the vehicle that he was under arrest at this time, and that the search that the officer was trying to conduct was related to that arrest. I believe that the testimony establishes probable cause to support all three of those elements, Your Honor. Therefore, the people would ask that this be bound over as charged. Count 1, resisting and obstructing. Count 2 would be the accompanying misdemeanor domestic violence. Thank you.
Thank you, Your Honor. Your Honor, Officer Fox did state that he never actually identified himself as a police officer, though he did state that he was in uniform. However, I think looking at the totality of the situation, this appears to be an event that Officer Fox himself escalated into a physical conflict. When he essentially kicked out Mr. Sims' leg, that seemed to set things in motion that led to conflict between the two of them. There was no issues with Mr. Sims and the officer who handcuffed him and walked him all the way down to the car. There were no issues between Mr. Sims and Officer Moore when he pulled him into the car. However, all of this stuff seemed to occur with Officer Fox, who began, like I said, getting physical with Mr. Sims, kicking out a leg, and that kind of set up conflict.
He said he did it after he gave a lawful order for them to spread his legs multiple times. So how is that Officer Fox setting something in motion and not your client failing to obey a lawful order?
Well, I believe my client was already at the car with a handcuff. I believe he certainly could have been patted down at that time based on.
How can we pat down your legs if you don't spread your legs?
Well, I guess we never got into, this specific distance between his legs at the time. I don't.
It was your witness.
Yes, that is fair. But we would ask the court to deny bind over on count 1.
Any re-argument?
No, Your Honor, thank you.
1 count of police officer assault and resisting and obstructing. The other count being a misdemeanor, the court will not need to address for the purposes of today. Mr. Sims, it's a preliminary examination, so that means that the prosecution only needs to establish more than mere suspicion that the alleged crime was committed and that you were the person to commit the crime. They don't need to prove each element beyond a reasonable doubt today. This is not a trial. It's a very low burden, and it can be based on the testimony evidence provided today by the witness. The court would be the sole determiner of any credibility issues of the witness. We had testimony from one witness today. That was Officer Mark Fox from the Lansing Police Department. He testified that on or about January 22nd, 2025 in the area of 1404 Glen Rose Ave, which is in the city of Lansing, Ingham County, state of Michigan. He reported to that scene. It was in response to a domestic violence complaint. He was the second officer on the scene. He stated that when he arrived, officer had someone else already in custody, that he was advised that the subject, later identified in the court today as Mr. Craig Sims Jr., had not been double cuffed. That could be double cuffed or secured the cuffs. He stated he had a conversation with the defendant about being searched and getting into the patrol vehicle. He indicated that he did not announce himself as a police officer when he arrived, but that he was wearing a full police uniform, and he was operating obviously in a patrol vehicle. And the defendant was advised and made aware that he was under arrest for domestic violence. He was going to perform a search incident to arrest. Asked the defendant, he said politely, to spread his feet wide so that the search can happen. He said the defendant did not comply after multiple requests from the officer. And so the officer stated he slid his feet out to perform the search by placing his foot in between the defendant's legs and kicking his foot outward. And then he testified that the defendant at some point body checked him by pushing his body up against the officer's body, and that the officer had to place or take or regain control of the defendant's arm and then place him up against the patrol vehicle. And he said he asked him, "Are you going to be compliant?" The defendant, he testifies, was yelling at him. He gave later some commands for the defendant to get in the vehicle. The defendant, he testifies, was not compliant with entering in the vehicle, and he had to try to push his head in. There was some cross-examining questioning with lends to the fact that maybe there was an issue with the seatbelt. Thank you for speaking out on the record.
I got a lot to say.
I know, but now is not your time to say those things. And when is your time to say it? You'll be sworn in and placed under oath for your own protection, okay? Nonetheless, there was an issue with the seatbelt, maybe not. That sounds like a question of fact that would be determined by a trier of fact as to whether or not there was something hindering Mr. Sims' ability to get in the vehicle. Probably could have been fleshed out, if that was the case, by a body camera, if that was an option, I don't know. That maybe demonstrated that there was something obstructing Mr. Sims' ability from getting in, but the court doesn't have that before them. So this is a question for a jury or a finder of fact that this proceeds to trial, if that was in fact an issue. The elements of the charge: assault, resisting, obstructing an officer, would need to be established by a probable cause standard today that the defendant either assaulted, battered, wounded, resisted, obstructed, or opposed or endangered, in this case, Officer Mark Fox, who is an officer of the Lansing Police Department. Obstruct includes the use or threatened use of physical interference or force, or knowing failure to comply with a lawful command. And so in this particular case, we have multiple alleged obstructions. Failure to comply with the lawful order to spread your legs, failure to comply with the order to get into the vehicle, allegations that the officer was body checked and that at some point he was bitten. I thought it was quite comical, the question about did he bite, was the bite hard or not? Doesn't matter. If there was a bite, there was a bite. It doesn't have to be hard. I don't think you get under any circumstances to put your mouth on anybody and bite. Nonetheless, second, that the defendant knew or had reason to know that the officer was a police officer and performing his duties. And there was a statement and argument as to the officer failing to identify himself as the police. He testified he was the second officer on the scene. So it's not typical where the second officer would arrive in full uniform in police vehicle, and as he's approaching saying this is the Lansing Police. That would be a little weird, but it could happen. However, he is in a fully marked uniform. He is in a police vehicle. There's already an officer on the scene who responded to a domestic violence situation, and it sounded like people were already in custody. So I think a reasonable person would know that he was an officer. Third, that the officer, Mark Fox, gave a lawful command or was making a lawful arrest or was otherwise performing a lawful act. I don't have any information before me that would dispute that he was making a lawful command or a lawful arrest because he's reported he's responding as a second officer to the scene of a domestic violence situation. Not to say that the defendant would be guilty of the domestic violence because we're not measuring that guilt, but that he was being placed in custody and under arrest for that charge, and a lawful commands are being given at that time. And the allegations that he failed to comply and or body checked and or put his mouth on the officer's hand. Fourth, that the defendant was acting, defendant's acting, assaulting, battering, wounding, resisting, obstructing, or opposing, or endangering the officer, either caused death or caused a suffer impairment of a body function or caused a bodily injury, not necessarily an issue here for the proofs, the purposes of the proofs. The court is satisfied that there's sufficient probable cause as to count one. Police officer assault, resisting, obstructing, that will be bound over to the circuit court as charged. Count two of domestic violence will accompany count one. Bind over date is going to be February 19th. That's the date the circuit court's going to get the file from the district court. Mr. Sims does not need to appear in the circuit court on that date unless Mr. Goodrich is making a motion for him to be rearranged. And your next court date will be a pre-trial in the circuit court. Your attorney will be made aware of that. Okay. The bond was set at 5,000 cash surety with GPS tether. And victim notification if possible. Correct me if I'm wrong. Was there another matter pending at the time that I arraigned him on this?
Your Honor, I believe he does have two traffic matters pending at 55th.
No, I mean, when I arraigned him, was there another matter already pending?
Not to my knowledge.
There was not, okay.
Would the court entertain a bond motion regarding that status?
Yes.
Thank you, Your Honor. Your Honor, and speaking of Mr. Sims, he does have a place he can stay with his grandmother across town, so he would be away from the alleged victim in this matter. He is certainly willing to do tether. He has no objection to doing that. He has been in jail for a couple of weeks at this point. There's been no allegations that he's made any attempt to try to contact her or anyone else regarding this. That would violate no contact. So I would ask the court to consider, if not a PR bond, at least a lower 10% bond that would allow him a chance to post bond here.
Yeah, he's gonna stay with his grandmother.
Yes.
And the East Jackson Street address.
Yes, Your Honor.
I'll amend the bond to 5,000 personal recognizance. The no contact order will continue, and the GPS order will also continue.
I may have missed it, but did the court already indicate that there's an exclusion zone for the ED victim?
It's got to be within, I probably said 600 feet. Let me double check. It says 2,000 feet. It's not within 2,000 feet of wherever the victim is.
Just check. Thank you, Ron.
You have any questions about the bond, sir?
No matter.
Any additional matters for the record, counsel?
No, Your Honor. Thank you very much.
Not from the defense, Your Honor. Thank you.
Thank you, Your Honor. Same to you, sir. And then, let's see, we have to bring up, we need to bring somebody else up. Bring Mr. Young. Can you bring up Mr. Young?
No.
Miss Delaney's also down in lockup.
Who?
Delaney, Michelle Delaney.
Oh, Delaney for a plea. Got it. Let's see here.
I think Delaney's gonna be an amendment to the bond because she is not gonna plead the fifth. I'm gonna seek consensus for the witnesses.
Okay, Mr. Brown Berrien?
Yes. Hi, how
Okay,
you doing?
I'm well, how are you?
I'm all right this morning.
Okay, I just saw your response. Am I allowed, is it possible to arrange a court date through Zoom? I did try to resolve it actually when you intended to pay. If you had told me that, I would have just wrote that on there and quashed the warrant, but you didn't respond to that portion.
I didn't see it. I'm sorry. It never popped up in the bubble.
Okay, yeah, it's just a failure to pay, show cause that I believe you failed to appear for. I don't have the final, how much does he owe?
Yes.
You owe $360. When are you gonna pay?
Can I start a payment plan, payment arrangements?
Yes, when are you gonna make your first payment?
Monday morning,
How much?
25,
Okay, and how often are you gonna make your payments?
every other week, but I'm gonna try to knock it down, but I just want to be held accountable for the 25. Oh, it's Mondays?
Oh, so you're gonna pay on Mondays?
Yes.
Okay, I'll note here that you'll pay $25 no later than Monday and $25 bi-weekly until paid in full.
Yes, ma'am.
Okay, you're all set.
Thank you. Have a great morning.
Same to you. Somebody can grab that file, right? This is the record of the people of the state of Michigan versus Paul Curtis Young, 24-03468. Appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. This is the Public Defender Aaron Schroeder on behalf of Paul Young. Mr. Young is seated beside me. He's just reviewing the advice of rights forms.
This is going to be a plea. Is that what it is?
Yes. Oh, and I have the sheet. If I may approach.
You can wait until he does advice of rights. And you can bring both.
Yeah, I got it.
And then there's the second page right here.
I got it.
Okay, can you sign right down here and print and give us an address if you're able?
Yeah. Right here, right?
Yes.
Weird. What's our docket for 25th of February? We only need to attend some meeting from 9 to 12 for the weighted case study.
We have competency exams.
If I may approach now?
Then I can't do
Can I
this.
approach, Your Honor?
Yes, weighted case study meeting. I'll respond to him later. Mark Conrad. Let's see. Okay, so you can stand. The offer is for you to plead guilty to the amended count 1 of attempted resisting obstructing officer. It's a misdemeanor. The maximum penalty is 1 year and or $1,000 in fines. That the people will dismiss the balance and the habitual offender notice. Is that your understanding of the offer extended to you?
Yes, ma'am.
Do you want to accept that offer?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
So help me God and on the Bible and morals.
Thank you.
Yep.
You can put your hand down. Okay. You still remain standing. Just put your hand down. Okay, I have an advice of rights and the information sheet. It's 2 pages. I'm gonna put the date on this one. Did you read these rights, sir?
Yes, ma'am.
You understand all the rights listed here?
Yes.
And do you have any questions about these rights?
No, ma'am.
Are you willing to give up all of these rights today in order to plead guilty to the amended charge?
Yes, ma'am.
That means you're gonna give up your right to be presumed innocent until proven guilty. So you're innocent as you stand there, and you have the right to maintain your innocence and require the prosecution prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. Do you understand that?
Yes, ma'am.
You want to give that right up?
Yes, ma'am.
You also have the right, if you proceed to trial, to remain silent and not have the silence be used against you. You have the right to see, hear, or question any of the witnesses called to testify against you in court. You have the right to subpoena witnesses that would testify on your behalf and present evidence at your trial that you believe show a defense to the charge being brought against you. And you have the right to waive your silence and take the stand and testify at your own trial if you like. You understand that?
Yes, ma'am.
Anyone threatening you to get you to give these rights up?
No, ma'am.
Has there been any promises extended to you if you enter a guilty plea today?
No, ma'am.
Are you currently on probation or parole?
No, ma'am.
You understand that by pleading guilty, it could result in a conviction that you may need to report to your employer, or you might need to put this conviction down on a future job application.
Yes, ma'am.
This also could have impact on where you could travel or get immigration, so you might want to travel outside the country on vacation one day, and this conviction could stop that. You understand that?
Yes, ma'am.
As to the amended charge of attempted resisting obstruction officer, how do you plead?
Guilty.
Factual basis, thank you.
Thank you, Your Honor. Mr. Young, back on November 21st of 2024, were you at or near a location of 500 East Saginaw? Near, there's a Quality Dairy there.
Yes.
Okay. And to the best of your knowledge, is that located in the city of Lansing, County of Bingham, state of Michigan?
Yes, ma'am.
And at that time, there was an officer that pulled up in a marked police car. Is that correct?
Yes, ma'am.
And the officer got out of that vehicle, correct?
Yes, ma'am.
And he was in full uniform?
Yes, ma'am.
Okay. And he gave you an order to stop, is that correct?
Yes, ma'am.
And you did not do that, correct?
I was struggling with being homeless at the time, and it was just a bad day like anybody ever has, so I didn't stop right away, but when he put hands on me, I stopped.
Okay, but initially you weren't stopping, which is why he had to put the hand on you, correct?
Yes, yes,
Okay.
ma'am.
And then there was some scuffle from there, would that be correct? There was some back and forth.
More like a misunderstanding. but
Okay,
yeah.
well, all right.
Yeah,
But you had no reason to think that at that time he wasn't giving
it
you,
wasn't excessive force.
okay, well. He did not, okay, you did, he gave you a command to stop and you did not, correct?
Yes, that's what I mean.
Okay, thank
by
you.
that. Yeah.
All right. Your Honor, if the court or the prosecutor have any further questions?
Just a couple, Your Honor. Mr. Young, the officer was in, I'm sorry, I might have missed it, but the officer you were interacting with was in a police uniform, correct?
Yes, sir.
And you knew that he was an officer?
Yes, sir.
And at one point he ordered. you
But
to-
they pull up in that alley all the time. I didn't know it
Okay.
was necessarily for me at that time.
Okay,
But you knew he was an officer.
Yes,
At some point during your interaction, he ordered you to get on the ground
yes, sir.
and you initially refused, correct?
Yes, sir. I just wanted him to take me in custody or do what he was doing with me standing with my arms behind my back.
Okay, so you knew he was giving you a lawful order and you refused to follow that order, correct?
Yes, sir.
Okay, no further questions.
I'm trying to figure out how we get from goes into the alley and then he ordered you to get on the ground.
I went to walk past him and
Okay.
he got out of the car because cops are in the alley all the time clearing everybody out. It's the alley by QD. And he got out of the car, just as he got out of the car, I walked by him and he grabbed me on the shoulder and then said, stop. I was like, no, man, I'm having a bad day or something along those lines. And then he went to grab me to make me, and that's when I proceeded to almost comply with a little bit of frustration, pulling away at the same time.
Okay.
I'm not gonna lie, I was having a bad day. Both my toenails fell off my feet from being frostbite.
Okay.
I was struggling with homelessness. So that interfered with my judgment, the way I interacted with that officer that day in a big way. And I take responsibility for that.
Okay, so the officer approached you, he told you to stop
Yes.
and you said no, or you kept going?
I didn't think I had any reason to, but once he used force, I pretty much gave in. I'm not gonna sit there and
Why was
fight.
the officer stopping?
Your Honor, if I may, were you originally told, you were at the Quality Dairy just prior to the officer interaction, correct?
Yes,
And they had told you to leave, correct?
yes.
And that's because you've been trespassed from there, correct?
I would go there and ask for change for a cup of hot coffee, and I can see why that's unwanted in front of a business, but when you're desperate to keep warm.
All right, did you get angry with those folks in there? Did you get aggressive, like talking aggressively toward them?
I just don't understand why they let some people do it and some people not.
Okay, but did
But
you?
yes, I did.
Okay, you did. Which is why the officer, you came to find out, that's why he was interacting with you.
Yes, ma'am.
Okay. And at some point, you also were carrying a rock, correct?
Yes, ma'am.
And it was when you were walking by the officer, you had a large rock.
There's a Chippewa Indian tribe ritual
Okay.
you can do with rocks to bring good fortune to you. That was
Okay.
the rock I chose.
Okay. But you did have a large rock in your hand as you were not stopping for the officer. and
Yeah.
just- Okay, thank you.
Okay, any additional factual basis?
Nope, that works. Thank you, Your Honor.
The court is satisfied with the factual basis. I'll accept your plea and find your plea made freely, voluntarily, and intelligently. My records reflect that he has about 30 something days credit. Is that accurate?
I believe, Your Honor, at this time, he is, I mean, our system is not exactly as accurate, obviously, as the courts, but I see it about almost 20 at this time. He's been on a no bond hold. He is homeless. He is on, but he does have a place to go. He would be going back to Ionia, where his family is. I have had contact with that family. He does have some mental health conditions that he has been getting treatment for while in the jail. And he has strong desire. He even gave me the name of the caseworker he's been working with previously in Ionia with CMH. So I'd ask the court to allow him to be released at this point, as this is now misdemeanor, so he can seek that out. Thank you.
Credit time, sir. He's all set.
Sorry, Your Honor, I did not mean that to come out the way it did. Time served, you said?
Credit time, sir. Yeah, he has about 25 days credit.
Okay. Okay, thank you, Your Honor.
Thank you, ma'am.
You belong to you, sir.
You know.
And you're done with the file.
Take that.
Yeah, take that with you.
Thank you very
and
much.
just Get yourself back to
Hi, Judge.
You said they don't have it or you don't?
I don't have it on this computer.
It's a pain to
I need to call AJ anyways, because I can't get on Zoom on my iPad.
Oh, jeez. Had all sorts of problems.
Yeah.
I
We
guess have a
need
good
AJ
rest of
here.
your
We
day.
need AJ here. He hates to see my name. And I couldn't get on the internet on my iPad. That was the other thing. Okay, on the record in the matter of the people of the state of Michigan versus Michelle Delaney, 24-01797. Yes, please.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Ms. Delaney, who is present standing to my right.
Okay, Ms. Delaney was scheduled today to have a preliminary examination on a delivery manufacturing of drugs, weapons control, substance drug house, and another delivery manufacturing drugs and weapons charge. How are we proceeding?
Your Honor, the people are going to request that count one be amended to.
That's the charge that was read off.
Oh, that's not hers.
Yeah.
Ms. Delaney.
Thank you for
I'm
catching
sure she
that.
just
Sorry.
probably, her head spin a little.
Yes.
bit.
That's why.
Police officer or
Yes.
security fail, OWI, and open intox is Miss Delaney. That was the file under hers. How are we proceeding?
Your Honor, the people are going to ask that count one be amended to attempt RNO. The people will submit an amended complaint to the court. We would also ask that this be set on the district court's docket and continue toward jury trial. And in so doing, the habitual offender fourth notice should automatically be dropped because there would be no pending felony. And also, just for the record, this would be a 5-count complaint. Count one would amend to attempt resisting, obstructing, then count two, operating without security, count three, operating while intoxicated, count four, open container in a vehicle, and count five would be the operating while license suspended revocated at 9.
Was officers here today?
I heard from my officer, she was, one officer was unavailable, the other officer was arriving late, but at that point, I decided to amend count one, so I called off that other officer.
Counsel?
I indicated to Mr. Nagel that based on the fact that he did not have his witnesses here, I was going to be seeking a dismissal of the case. There was going to, and he indicated they would probably reissue then, and then there was this discussion about amending to the attempt instead.
He's gonna reissue on an attempt, you mean?
Well, no, on the original charge.
It won't be this
Felony.
dismissal would only be as to count one anyways.
And
The other matters were still gonna continue. Because it's an operating while intoxicated, the misdemeanor motor vehicle, security, opening, alcohol. And then operating and suspended, all those are misdemeanors. There's only one felony, so.
Just to clear up the record, that's correct. I had anticipated that there was going to be a motion to dismiss, and so I had just sort of indicated that under the circumstances, we would reissue, but then when I took another look at the complaint, I realized exactly what the court just pointed out, and that's when I decided that.
yes,
On second thought, what we're going to do is we're just going to amend this to the misdemeanor. And it was after that conversation, I heard from my officer and told the officer what I'd already planned on doing, so. The court's absolutely
I
correct.
recognize but my concern is that was a strategy because the officer didn't appear. That's my concern.
I understand. At the time that I heard from the officer, I could have had the officer here by now. I had called her off at that point.
You called her off
Or not at the point.
after she was not here, so. Is my concern, correct?
Well, that's correct.
Was this something that should have originally been charged as an attempt in the first place?
I think it could have gone either way, to be perfectly honest, Your Honor. I think it was charged the way it was because of all of the other, all of the other things that were happening at the same time.
I read the affidavit of probable cause. I don't think this was, it was charged the way they reflected it, which was not an attempt, but it was a police officer assaulting, resisting, obstructing. I don't know why the officers were not here at 9 o'clock when they were supposed to be here. Counsel, how did you want to proceed?
Your Honor, I'd be asking for dismissal of the felony charge at this time.
Count one is dismissed as the most, without prejudice on the motion. The other matters will convert to the misdemeanor docket.
For the record, Your Honor, that's a dismissal without prejudice.
Correct.
Thank you.
And so that means that they have the right to reissue count one against you as a felony, if the officers are ready to proceed on this matter, okay?
Okay, may I, Your Honor?
Yes.
Ms. Delaney, what that means is without prejudice means that because this is not a jury trial sort of a situation where there's a dismissal or a finding of not guilty, which means prejudice attaches, meaning case can't be brought again. Because we're not even close to that point right now, it's without prejudice, meaning you're not prejudiced by the idea that if the police come back later and, oh, there's a reason why we weren't here, and the prosecutor reissues that felony charge, there's nothing stopping them legally from being able to do that, the prosecutor. So there's a possibility within the statutory timeline of statute of limitations that this could be recharged. But that would be up to the prosecutor and it'd be up to the officers if they talk to them later, okay?
Do you have any questions about that? No. Okay, the pre-trial on the remaining matters.
March 3rd at 10.
March 3rd, 10 o'clock in the morning is your pre-trial date on the remaining matters, okay?
Yeah.
And she's in custody on what?
She's in custody out of Clinton County on, I believe. Okay, that she indicated, Your Honor, I used to know this and I apologize.
Well, how long is she gonna be in custody? That's
She,
my-
okay, the at least until the 11th of this month. She, I believe she has a sentence. There is a sentencing date coming up that I believe she is going to result in her being sent to treatment in Clinton County on that charge. And I can look up further regarding the actual charge and yeah, here we go. Hang on. Pardon me, Your Honor. It appears it was for disorderly jostling, person jostling that's, yeah. I got reduced. Yeah, and she pled guilty to, and now they're making sentencing.
Okay, I'm gonna instate a bond 500 cash surety on this. And you'll contact us if it needs to be adjusted for her to go into.
All right.
Treatment. It's just, she's on remand right now. There was no bond.
Yes, Your Honor, I was going to address that. I will reach out to her attorney, Mr. Samuels in Clinton County, to communicate that. He can contact me if we need to adjust it. Thank you. There might be an extra thing I need to do.
I'm gonna let that. if it goes in. I mean, if Tom and Mr. Samuel. Okay? Yes. So I know what happened and tell him that if he needs to do anything further down here, let me know and I can get the paperwork, to it, okay? All right, thank you. Thank you. Have a blessed day. You too.
We're gonna get you a copy of your dismissal.
That's your notice to come back. I need to make sure, if you are in treatment, I need to make sure I know that. Oh, no, that's absolutely fair. You know what's, you know what, right back, what they're looking to say. Okay.
All set, thank you.
Yeah. Take care. I'll be in touch.